welcome everybody to our bi-weekly webinar. My name is Ryan Poole. I'm the co-host with Jim Brown, real estate attorney. And, this is a bi-weekly webinar that we share with agents to add value to you. One of Jim's favorite sayings, iron sharpens iron, and we're learning from each other. Some massive changes in the real estate industry, obviously with the NAR settlement. We're going to be going over part of that today. On part two, part one is going to be talking about the new HOA laws as far as parking, so we can be knowledgeable agents with our buyers and give that new information that's just came out and those new laws that are passed. But a little quick about myself. I'm a real estate agent, been doing this over 20 years. Love the business, love working with buyers and sellers, and love working with other agents. I'm also the founder of RealTrade, which is an online marketplace and social media platform for real estate. I really didn't like what Zillow was doing, which was pinning agents against each other. So the big value proposition of RealTrade is we have thousands of buyers and sellers on there. You can create a free profile and get free leads from your listings. And also if you're a buyer's agent, they can discover you through the social feed and actually search agents. So I actually want you to check it out. You can check out realtrade.io and register, and it's free for agents. And of course, my co-host Jim, the quintessential entrepreneur. Not only is he a real estate attorney, he's the founder of New Path Title, which is an awesome title company, and an amazing closing software called Title Leap, which is like a free contract coordinator. So I love all my closings with Jim using his software. It's one of the best out there. So go ahead, Jim. Why don't you take it away?
And before we get into it, I want to just briefly mention there's a pending restraint on trade lawsuit regarding pocket listings. I think that could really be a boon for RealTrade.
Well,
I
that's a
think
big thing.
that's an artificial restraint on trade in favor of the agents that's gonna help the agents, and it'll be interesting to watch that play out. So I'm Jim Brown. I'm the founder at New Path Title and Title Leap and James Brown Law, and enjoy this business more than I've ever enjoyed it. And my favorite part of practice is actually working with agents. So if anybody texts me and the first thing they say is, "I'm sorry for bothering you," we're going to have a problem. Because when you text me and you want to talk about something, it's always food for thought and it expands my knowledge. So never start with apologizing for taking up my time. It's my favorite part of what I do. We're going to try to keep this short, 30 to 40 minutes. It's going to likely run longer than that. We're going to do it in two parts today. There are no bad questions. Put the stuff in the comments. You can text me 24/7. Go to newpathtitle.com. You can email, you can text me transactional issues, future podcast issues, whatever it is. My kids are grown and gone, and I love doing what I do, and you guys give me the opportunity to do it. If you turn your camera on, I can see your reactions. It helps move through the material quicker. We'll have a question and answer session at the end, and Ryan and I will go over a few time-saving tools to make you guys more efficient. And having said all that, when you're ready, Ryan, I'm ready.
Yeah, go ahead. Share your screen, Jim, with the outline.
All right. So here is my thoughts on the new, sorry, I have to crane my head because it's on the bigger screen. Here's my thoughts on the new Florida legislature enacted parking rules. There's a whole bunch of stuff that just came out from the Florida legislature. Some of it was renewing laws from last year. Some of it's laws new this year. It's called the Homeowners Bill of Rights. And I'm subtitling it, "Agents Pump the Brakes. Be careful what you say to clients before you possibly say too much." That's a controversial statement. My goal for you guys is you want to hear stuff that you don't hear every place else. This is the forum. I scour YouTube, listen to podcasts by pundits, and there's a whole lot of misinformation on this topic. I listened to a bunch of news articles from popular news stations all over the state. New laws cover everything from parking to commercial vehicles to trash cans to AC installations, clotheslines to stop letters and swing sets and COVID masks. It's all in here. You just got to be careful what you say. I've seen social media posts and YouTube videos by some lawyers summarizing the law, giving incomplete and wrong answers. And I met a lawyer yesterday who makes their living suing realtors. As disgusting as that is, there are lawyers that make their living suing agents. And if you think that the tort reform laws put personal injury lawyers to the curb as far as looking for work, they're not looking for work. They're finding other ways to make money, and they're coming after, unfortunately, some real estate agents, and they're just trying to get in their E&O policies. Why do these laws matter? Because every one of these rules is an opportunity to make a property more attractive to a buyer or set expectations in your seller. That's self-explanatory. If you know the laws, you just look like an expert. When a buyer calls you in 6 months after the sale with HOA pain, you also stand out in their mind as an expert if you rattle off the rules. Roughly 1/3 of all Florida homes are in an HOA. Hold pause. That's huge. How many homes are in Florida? 3.2 million, right? There are almost 50,000 separate HOAs in Florida. Wrap your head around that. I can't even, it's inconceivable. We're second only to California, but California has twice as much population as Florida. Almost 1 out of 5 cars sold in the US is a pickup truck. This is where it becomes, where the rubber hits the road here. Back when a lot of these association rules were written, pickup truck sales were a much smaller fraction of car sales. These laws do not apply to condominiums. I've received several calls from agents about that. These laws apply to associations with public or private streets. So everybody knows the difference between public streets and private streets in an association. An association that has a gate almost every time is not going to have public streets. Associations that don't have gates many times have been donated to the community, to the public, to the municipality, and we're going to go over later why that matters. Be careful explaining these rules. There has been some pushback from HOAs following the new laws. Don't explain them as an absolute, like I've heard several agents do. We'll talk about this more. What sometimes agents say to me, oh, lawyers always find a loophole. And I agree and I disagree, and sometimes I'll hear agents say laws are always gray. In my mind, I'd like to think laws are black and white, but the reality is they are gray. And in this situation, the law was, I won't say hastily rushed out, but there are some problems that are going to come up with this, and we'll go over more about that in a minute. 6 months ago, I was selling a personal investment property in a steward association. The buyer wanted to pay the full ask before it was even on the market. I was so excited, but the contract fell out because the association did not allow vans. I had no idea he drove a van. Had this law been in place, I would not still have the property lingering on the sale in a terrible market. I mean, we got to know the rules. The reality is I didn't rush to market. This guy wanted to buy it. He strung me out for a couple weeks, and by the time he strung me out for a couple months, because I let him, the property was in rehab. But the reality is, had I known this rule was coming, I could have used it to my advantage. And he would have bought for the full ask back in the day before things are what they are today. What are the biggies of the new, existing, and renewed laws that make up the HOA Bill of Rights? There's a whole lot of technical stuff here. I tried to summarize it the best I could, not make it dry. But the HOA can no longer ban homeowners or their invited guests from parking personal vehicles, including pickup trucks in their driveways or any other area where they have a legal right to park. Anybody has any questions? We have a small enough group. You can just chime in, go off mute. I have no problem pausing.
Just to be clear, this is for HOAs, not condos. 100%.
This is just HOAs.
Yep.
Does not apply to condos and applies to HOAs whether they have public or private roads. Only one of these rules doesn't apply to condos with private streets. HOAs can no longer prohibit parking of personal, business, or first responder vehicles, including pickup trucks and vehicles with commercial signage that are not considered commercial vehicles. Commercial vehicles are defined as weighing more than 26,000 pounds or having more than 2 axles. Monster SUVs that I've seen are well under 6,000 pounds, certainly under 10, and the smallest trucks I've ever seen with more than 2 axles are tow trucks. So this is a pretty liberal application of the rules. Everything you can imagine is going to be considered non-commercial until you get into really monster vehicles. HOAs can no longer require homeowners to choose their vendors from a preferred vendor list. This is all under House Bill 1203. Yeah. HOAs cannot restrict. So there was a whole bunch of issues. I don't know if you guys have ever run into it, but I had issues where people would want to have work done on their property at an HOA. They'd submit a plan, and the HOA would say, "Oh, the plan's not sufficient." So many times that the homeowner would end up submitting a plan that worked with their vendor list because the homeowner eventually said, "Well, what vendor can I use that you guys are going to approve? This is not lawful." There was an association in Miami that was just half a dozen people were indicted and convicted of felony criminal charges. And I think it involved $2 million plus in misappropriated fees to vendors that were giving kickbacks. HOAs cannot restrict access to homeowners' property for contractors or workers based solely on their absence from the preferred vendor list. Same thing. They weren't allowing trucks into the community if they weren't on the preferred list. They were claiming it was for insurance reasons. There's a million ways that homeowners and vendors not on the list could get around that. Some HOAs are refusing to comply, more below. Some unit owners were paying $1,000 a year for offsite parking. There's a case in Tampa where there was a homeowners association. They didn't allow parking, and they were pushing the people to go to a preferred lot. They had 300 cars a year. It's almost $500,000. They were collecting in revenues from people not able to park in the HOA. It gets bad. I see Ryan shaking his head. I mean, there were shuttles, there was all kinds of stuff that they were providing. The shuttles had a price. I mean, it was ridiculous. And there was a couple of good news stories if you want to surf YouTube looking for it. House Bill 437 limits the ability of an association to penalize the homeowner for having certain items in their backyard that are not visible from the street. Swing sets, clotheslines, trampolines, etc. Some associations were actually flying drones over the property and filing fines and leaning the property relatively quickly. House Bill 919, estoppel letters. Big one for title agents. Tajay, Christian, Decoya, if you guys are listening. No more rush fees. Shortens the delivery times from 10 days to 5 days. So when your title agent, if it's not us, tells you we're waiting for the estoppel letter, they are only waiting 5 days. If they tell you more, or they're telling your client they need fees for a rush, an additional fee for a rush, those laws no longer control.
Wow. You know what's rough about that though, Jim, is Christian especially, I know he's on here, is that you can sometimes associations charge a seller too much, and Christian will go and get the Florida statute and send it to them, but it doesn't mean they're going to change their fees for you. You know what I mean? I feel like it's going to be the same thing for the rush fee. Who's going to actually enforce that? Especially, your seller just wants to sell. Who's actually going to enforce that they're not charging you a rush fee, or you know what I mean?
I'm really glad you mentioned that, because at the end of the show, or at the end of this section of the show, we're going to talk about the private right of enforcement and what that means in practical reality. It's terrible. There's all these great statutes, but what's the enforcement mechanism? It's called a private cause of action, but we'll go over that in a minute. Exactly.
Hey, James Madeline, a question before we get too far. Can we now park in the street if the driveway is full?
Any place where the homeowner has a right to park. So if you have a restriction in the entire community that says no parking in the streets ever for any circumstances, that would be community specific. But if the right exists to park in the streets, like most communities that I know have, I would imagine there's no way that they could fine you. I mean, a lot of this stuff is emerging, but if there's no blanket prohibition on street parking, if you have a right to park in your driveway, you have a right to park anything you want to park in your driveway now.
Yeah, I have a question, Jim.
Yeah.
So in my subdivision, my driveway is good enough for 5 cars, but we're not allowed to park in the street, and that's part of our HOA documents. And that was to park in the street. Obviously, if you have a company and a party, they don't say anything. But having vehicles there for a whole day or an overnight on the street, it is a violation.
That'll be, I would imagine, that'll be problematic. The law doesn't say that you have a right to park in the street. The new law says that you have a right to park wherever you have a lawful right to park whatever vehicle you want. It doesn't talk about the location of the parking.
Okay. And commercial vehicles, I missed that. I apologize. I was at a home inspection.
That's okay. I'll send you guys the outline, but basically commercial vehicles are going to be anything, non-commercial vehicles are going to be anything under 26,000 pounds and anything with less than 3 axles. So that's going to be just about everything. Your gigantic Sprinter van is going to qualify. Your limousine is going to qualify. Everything is going to be qualified as non-commercial unless it has 3 axles or weighs more than 26,000 pounds. And that's a pretty substantial vehicle.
Yeah, if it's not commercial, right?
Then you can park in your driveway. Yep. Estoppel letters, no more. Chris, what do you got? I think you're muted.
So, yeah, sorry, I don't unmute. So, Jim, if you have commercial lettering on a personal vehicle, how is that viewed?
That commercial vehicles, I think it's up here, commercial signage, HOAs not prohibited personal vehicles or first responder vehicles, pickups with commercial signage. So commercial signage is now lawful to park within the community, even if it's prohibited in the decks. So if you can have a truck that has a little GC number and it's innocuous, it's inconspicuous, and it's a white truck with a little black GC number. Or in theory, you could have a truck that's lettered top to bottom, like you see some of the law firms driving around in a monster stretched Hummer with the law firm lettering all over the side of the vehicle.
Okay.
Stopple letters, no more rush fees, shortened delivery times. Requires, House Bill 919 requires 2 weeks notice before HOAs can start fining or penalizing violators. Trash cans can be left at the curb 24 hours before or after pickup time, before violations. And Christmas tree lights require a week's notice before the association can find the homeowner to take them down. Yes, the law contemplates Christmas tree lights, but it's not like you guys are going to use this stuff in your practice unless your buyer calls you and they're having friction. And then you guys look like the star. I mean, the reality is all this stuff is pregnant content for you guys to distribute to your clients. So if you've done work for clients and HOAs and you want to get in front of them, stay top of mind, you send them a reminder. Hey, are you guys aware of the new HOA laws? I had several clients that got listings under the new Senate Bill 4D stuff that Ryan and I talked about a long time ago, just by sending around reminders to their clients. Hey, did you know this was coming? And it generated sales. Christmas tree lights require, let's see, we talked about that. Here's a biggie. So I've received calls on this already. City of West Palm code violation officer is driving in front of my office right now. I received calls on this. Face masks. People are up in arms that there's a Florida law now, older people in older communities regarding face masks. So the law says in places of business, proprietors, managers at HOA common areas, they can't require, and this probably would extend to condominium associations also. I just thought of that one. They can't require face masks or disclosure of vaccination records. And yes, there were fistfights. I know of one of them at Frenchman's Creek. House Bill 949, golf carts can only be operated by persons 18 years of older with a government ID, a driver's license, or younger if they have a learner's permit. And I've had people call me about this, and that's law. Now, here's the one exception where it only applies to HOAs with public streets. So if you have private streets, this law doesn't apply. So if you see a gate in a community, that's the distinction. How are existing associations getting around this? The hot topic is not that the law exists. The hot topic in my mind is, if you're a real estate agent, how do you explain the new law and not get into trouble for not explaining it properly? some associations are not participating in the new law. There is a Florida case, an old case called Kaufman, and some associations are applying the Kaufman rule so they don't have to comply with the new statutes. And this sounds nitpicky, and I heard a lawyer on YouTube completely misexplain the rule. And what they're arguing is the Kaufman language makes their statute, makes their declaration of covenants and restrictions immune to the changes in the statute. What does Kaufman language say? Kaufman language simply says, somewhere in the declaration of covenants and restrictions, it's going to say, this community shall be governed by chapter 718 of the Florida statutes, as same may be amended from time to time. This part about as same may be amended from time to time, that's the critical thing that
today.
makes the decks subject to the change in the statutes. Without that language, the decks are not amended by the new statute. So some associations, particularly on the West Coast, for whatever reason, this issue is hotter on the West Coast than the East Coast, are not complying, and their lawyers are telling the association this is why. Some of our higher end communities, some of our higher priced communities don't want to live next to driveways with commercial vehicles. They also can't tell you you have to park your vehicle in the garage if the garage is available, or you know, all kinds of different rules. Some communities with high price points are standing up and not complying. I have not seen this on the East Coast. I haven't heard about it on the East Coast, but it's absolutely going on. Many older communities, does anybody have any question on that? Do I expect you guys to understand the distinction? It's just keep in mind, some declaration of covenants and restrictions don't have certain language and may not confine to the law, may not have to comport to the law. This will be sorted out in the appellate courts, and certainly it's going to be tried. It's just a matter of time. In the meantime, you want to make sure you're telling your buyers and sellers there are rules, but there are, you know, you want to give them the general rule, and you want to say, but it's subject to a review of your declarations and an opinion from your board. Many older communities do not have Kaufman language in their decks. And if it was not in there from the start, then it could be tough to get this stuff passed retroactively. It's very tough to get it later. Contract law. So that's one reason why some associations aren't comporting with the new law. Here's another reason why some associations are not complying with the new law. Basically, everyone that bought an HOA entered into a contract with each other through the HOA. The declaration of covenants and restrictions are recorded. So everyone took title with notice of the rules, the decks, whether they read through them or not. We call them the decks. In the decks, the owners agreed to do or not do certain things. Among them was not parking commercial vehicles. As much as I support the effect of the law, I fundamentally disagree with the exercise of statutory authority that invalidates private property rights. This may seem small, but it's a super slippery slope. What if the Florida legislature all of a sudden said all deposits in all purchase agreements, in all sales contracts, have to be always refundable? Parties could do what they want and contracts would have no value. So that's a terrible example. It's an example of something that would be terrible. That's an invasion of property, private right to contract. This is just another perspective, you guys. If you have a hard time with wrapping your head around this stuff, I'm just sharing with you my experience of being being an attorney for 20 years and being in the business 40. Private property rights to me are fundamental. The ability to enter into contracts is fundamental. When people bought in an association, they entered into a contract with the association for the benefit of all the other homeowners. I love the fact that everyone knows, let's see. The fact that everyone knows if you don't close, you lose the deposit, makes outcomes predictable and gives you value to the contract and the transaction. Contracts in general raise values to properties. Contracts make predictable outcomes. if you have the legislature vacating contract rights for policy reasons, uncertainty creeps in. Contracts give people predictable outcomes, certainty and value. No contracts, no predictable value. I know some people are going to disagree with what I just said. I'm just sharing with you the my personal perspectives and some of the justifications as to why the Florida legislature writing rules, rewriting contracts may be problematic. I may not like the outcome of the law being taken away, but I know I dislike more the idea that government can limit or take away your right to enter into and enforce private agreements. It's a slippery slope. Be careful what you wish for. Parting thoughts. Clearly, COVID changed the work, home environment dramatically. And so here are some of the policy things. More people having commercial vehicles because they're self-employed or have company cars working from home. The impacts of upper and lower price communities will have reverse arguments. I have friends and clients in communities priced over $750K and lower that are ecstatic over the change. I have potential clients calling are furious that may have a pickup truck or worse, a commercial vehicle in their neighborhood's driveway tomorrow. So everybody has a polar opinion, a polar opposed opinion on the topic that I've talked to. Who enforces the law? To Tajay's point, who enforces the new law? DBPR is not. Only a private right of enforcement currently exists. What does that mean? So if homeowners want to enforce this thing, they have to file a suit. What does that mean? You got to spend money. You have to pay and hire a lawyer. If the association is sued, all the association has to do is retain a lawyer at the homeowner's expense. If the homeowner loses, they could owe their attorney and the HOA. If the HOA loses, all they do is raise assessment and subtract the dues and pay their lawyer. This is terrible. Do I like the law? Yeah. Do I want to confuse you guys? No. But do I want to explain the landscape with which we operate so we can all do the best job possible? Yes. So if you guys have any questions, I'm on it. If you don't, let's move on to the Sitzer NAR settlement forms update, which wasn't very well advertised, but I want to cover that stuff. What are we into it? 10:30? I think we can move through this stuff pretty quickly. Does anybody have any question on the controversial perspective I just dropped on you guys on the new easy to understand parking laws?
No, it was good. It was great information. I mean, obviously, us agents, we sell in plenty of HOA communities. So I've had deals blow up myself, just like you, because of a commercial vehicle or a van. And it's nice to know that, hey, you could put that deal together by letting the listing agent know, especially representing the buyer, about the new law. So
and my goal is when you guys tell your client something carte blanche, like, oh yeah, parking is completely permitted and all these new rules apply, just be careful that you don't commit to writing or say too much like it's absolutely concrete. You want to make sure here's the law and it's subject to your board's interpretation. And if they say why, I gave you a few talking points: private property rights and coffin language. And now you look like the expert, the hero. You've told them the law, you've told them the reasons. You don't have to go down the rabbit hole. If you're using the new buyer's agency form, there's some beautiful language in there about that buyers have to contact there's some beautiful language in there that gets agents out of trouble for saying too much, if they do happen to say too much. All right. Do you see any other questions, Ryan, in the chat or anything?
are the HOAs, James asked, are the HOAs going to revise their decks? Do you think that's going to be something that they're going to amend their decks?
It's tough to do. Guy Quattlebaum is on the podcast with us. He's our litigator. It's tough to do. It takes a big vote, and it takes, who's going to. Do I think it could happen? Yeah. Do I think people will revise their decks to add Kaufman language? No. Do I think people who want to have certainty and then the outcome and they can get enough votes could vote in the cars? Yeah. Could vote in the parking stuff? Yeah. And I think a lot of associations are just going to have the new laws take control and parking will be accepted. As long as nobody makes uphill, it's just going to be generally respected that the new law controls. Certainly the laws on things in your backyard and things that go on in your house. So the new law also affects a homeowner's ability to do whatever they want as long as it's not viewable from the street without association approval. So there were some associations that made getting a new AC installation a permanent activity from the HOA perspective. You know, what goal does that serve? You no longer have to do that. Do I think that's going to get uphill? Absolutely not. Do I think the law about trampolines in the backyard and things that aren't viewable from the street might get some uphill in some upper end communities? Maybe, but I doubt it. But I think the car thing could be controversial, and so you have to be careful as an agent how you explain that.